Sigel, John Kane here from Let's Talk Native. So, the white men on the Seneca New York State Arbitration Panel ruled for the state. Ooh, what a surprise. But don't go writing any checks against revenue sharing payments just yet. That goes for the governor and the 3 Western New York mayors lining up at the free money trough. Sure, you got your ruling, and now with this rewrite of the compact, revenue sharing is no longer an agreement, but now an imposed fee. The problem is that while these 2 white men rewrote the language of the gaming compact, they didn't rewrite the underlying federal statute that regulates the states on native gaming. And therein lies the problem. While the Senecas remained willing to make revenue sharing payments, there was no real reason to question whether this onerous provision was legal, although it certainly could have been, and it sure must be questioned now. The state would be hard-pressed to prove that what they call an exclusivity provision was worth anywhere near $1.4 billion. In reality, the state gave up nothing for these payments. The state already prohibited Class 3 gaming, and from the moment the Senecas and others began to build the native casino market in the state, New York began expanding their Class 2 gaming at their horse racing tracks to grab some of that market. So, to the extent that New York State could compete with Seneca Gaming, they did compete with Seneca Gaming, even in their much touted exclusivity zone. Now, whether this violation of the spirit of the agreement actually violated the language of the compact, that became moot in 2013 when the Senecas agreed to a settlement on their claim to a breach of the compact. That settlement had the state surrender $200 million to the Senecas. Otherwise, the total payments to the state would have been $1.6 billion. But what is undeniable is that through the 14 years of revenue sharing laid out in the gaming compact, while the payment rate increased from 18% to 22% and ultimately to 25% of the net slot drop of Seneca Gaming's slot machines, the value of the exclusivity decreased with every slot machine the state's racetracks put into service. And the problem with that is federal law. The Indian Gaming Regulatory Act, IGRA, which specifically gave the states a role in native Class 3 gaming, prohibits states from imposing taxes and fees beyond the expenses incurred by the states from native gaming. And revenue sharing has rules. In order for revenue sharing to be legal, a state must provide a concession that is both substantial and quantifiable in exchange for revenue sharing payments. By substantial, the concession by the state must go beyond the value of the payments to the state to have any meaningful benefit, and in this case, to the Seneca Nation. And that value must be measurable and provable, or quantifiable. Now, as I said, New York State simply cannot prove that their concession to Seneca Gaming so benefited them that the payment in excess of $1.4 billion was worth it. In fact, the state implicitly acknowledged they devalued their concession and surrendered $200 million in an effort to compensate for it. Additionally, as a matter of fact, in the 14 years of this revenue sharing of Seneca dollars, not only did $1.4 billion get paid, but over $1 billion of market share was taken by the state from native gaming in this ever more crowded gaming market. The state not only couldn't protect the Seneca gaming market with more competition from border states and the growing Canadian gaming industry and the economy in general, but they willfully became the Seneca's biggest competitor for gaming dollars in the region that they were being paid to protect. That starts to look more like extortion from organized crime than an amicable agreement. But while most of this focuses on payments made in the past, the one thing is clear. New York has not provided protection to the Seneca gaming market. It did not, it does not, and it will not. So what possible justification can there be for paying another $1 billion to the state through 2023? I know what the 2 white guys on the arbitration panel would say. You paid 14 years, so just keep paying. Fortunately, these 2 morons are not arbitrators of federal law. So here it is, the bottom line. Under the Indian Gaming Regulatory Act, states are entitled to no revenue from native gaming unless a revenue sharing agreement exists where the states provide something of value that must exceed the revenue payments and be a substantial benefit to the native gaming enterprise. Not just a wash, but a benefit. That's not what exists here. Not only have these two white men altered the compact so that it is no longer a provision the Senecas agreed to, there's no way a reasonable person, let alone an expert from the gaming industry, can quantify any benefit to the Senecas sharing their revenue with the state. If paying the state benefits only the state and the competitors to Seneca Gaming, then the revenue sharing is illegal under federal law. The state licensed casinos, including the racetrack casinos, have gone on the record and said simply that they cannot compete with Seneca Gaming if the Senecas don't make payments to the state. Newsflash, the Senecas were not paying to level the playing field for their competitors. They were buying an advantage. Right now, the only advantage and real market protection the Senecas enjoy come from not paying the state. There's your exclusivity. So stand and fight, Senecas. We are all standing with you. Yahweh.